Welcome back, everybody, to our study of the English legal system. In this lesson, we are moving away from talking about primary legislation, which is the way in which law is made within Westminster, and now moving on to talking about delegated legislation, which is slightly different and exists in a number of different forms. And we're not going to spend too much time focusing on delegated legislation because I want to get to looking at the idea of judicial precedent and the way the courts operate in England and Wales instead. So ultimately, the previous lesson, as I mentioned, examined the process of passing what we describe as primary legislation. This is law that is passed by Parliament. Okay, so a bill goes through Parliament, it goes through the various stages: the first reading, second reading, committee stage, report stage, third reading, goes to the House of Lords, then it goes to royal assent, and then it becomes law. It becomes primary legislation. This lesson is talking about the making of and the different types of what is described as delegated legislation. Now, the first question you should be asking, if you don't know what delegated legislation is what is delegated legislation? Ultimately, a piece of delegated legislation is the process by which law is made, not by Parliament, but by a particular individual or organisation, on the basis of authority which is granted to them by Parliament, by a piece of primary legislation. So sometimes Parliament can pass law that allows for the institution or organisation which it regulates to make legislation, to make law, to make rules relating to that particular issue in that area. And within this relationship, you see that primary legislation is sometimes referred to as the enabling legislation, because what it does is it enables the delegated legislation to exist. It also enables those who are in the process of creating secondary legislation to be able to create said secondary legislation, secondary delegated legislation. Now, ultimately, we can identify three main types of delegated legislation when we think about how lawmaking works in England and Wales. We can talk about orders in council, we can talk about statutory instruments, and we can talk about what are things known as bylaws. Okay, let's do them one at a time. So the first question is, what is an order in council, or what are orders in council? Orders in council are made by the Privy Council. The Privy Council is made up of the Prime Minister and other higher authorities within government, so other members of the cabinet, usually very high senior civil servants. And given the fact that the Privy Council forms part of the government, what happens here is we see the use of orders in council for the government to be able to pass laws without the express consent of Parliament. So it is almost like something of a workaround when it comes to the passing of policy and the passing of legislation. It is not expressed because there is still influence on Parliament here with the passing of what is known as enabling legislation. So a order in council is the ability for the Privy Council to make the law in certain circumstances, and these certain circumstances are limited and regulated by Parliament by the enabling legislation. So you might be thinking straight away, well, isn't this surely a violation of parliamentary sovereignty, or maybe a workaround of a democratic mandate that Parliament has to hold the government to account if the government can just pass law, delegated legislation through the Privy Council? Well, the answer to that question is, of course, no, because even though it goes through the Privy Council and under the authorities of government, it is still regulated by a number of pieces of legislation that is passed by Parliament. So the enabling legislation. So, for example, we have the Civil Contingencies Act of 2004. That is the enabling legislation. That is the primary legislation that is passed by Parliament that allows for the Privy Council to make law in a state of emergency. So this is an order in council for the Privy Council to make law in a state of emergency. You might think, well, surely that violates and goes around Parliament. No, because it is regulated by the Civil Contingencies Act of 2004. Statutory instruments are laws and rules which are created by specific government ministers under a particular policy field. Okay, so they are authorised to do this under the remit of a particular piece of primary legislation. So again, this is delegated in the sense that it is enabled by the primary legislation that is given, but it is giving government ministers the ability to create secondary legislation. Now, some of the reasons why this is so useful is because there's lots of regulation that may take place that may require reform or lawmaking be done in a quite quick and simple manner. That doesn't necessarily require the full process of passing a piece of primary legislation through Parliament and getting royal assent, because that is a long, lengthy, costly, and quite heavily time-intensive process. A good example of a statutory instrument is the Ministry for Justice making changes to the police codes of practice under the Police and Criminal Evidence Act. So under PACE, there is the allowance for the Ministry of Justice to be able to create and make changes to what is known as the police codes of practice. There are quite a few police codes of practice, actually, and for those of you who want to have a bit more information about police powers and the Police and Criminal Evidence Act, we're going to get onto that when we look at public law in more detail in the future. But you can see here that the police codes of practice can be changed and they can be reformed, and new police codes of practice can be introduced under a specific government ministry under the Ministry of Justice, and this is all enabled by the primary legislation, the legislation which is PACE, the Police and Criminal Evidence Act. So essentially what these codes of practice do is form part of the particular policy of policing guidelines, ultimately. Finally, then, we have bylaws. A bylaw is simply a type of law that can be made by local authorities and local councils. So often there's lots of regulation and different things that can be done at a very, very local level by local councils that wouldn't make sense to be made by Parliament at the central government level. So, for example, given the localized nature of bylaws, you can see the kinds of relatively menial interests that they protect and that they regulate. So things like parking restrictions or cycle lanes, these are going to be obviously regulated by the council. You don't expect a cycle lane to be introduced in a leafy green village by Parliament itself, and that's why bylaws are so important. And again, they are still also regulated. Councils are regulated by Parliament, and they are subjected to and subordinate to Parliament, and so the legislation that allows for bylaws to be created by local councils is the enabling legislation which creates the secondary legislation, which are bylaws themselves.